right, appellant ready to proceed?
May it please the court. My name is Lauren Curtis. I'm here on behalf of the petitioner, Star Insurance Company, and I'd like to reserve 5 minutes for rebuttal, please.
All right.
Star Insurance respectfully requests the court to grant its petition for certiorari and quash the trial court's order that denied Star's motion to dismiss based on the non-joinder statute. By way of background, this is a wrongful death action filed by the respondent Dominguez concerning a motor vehicle accident. Ms. Dominguez was struck by a vehicle owned by Hillsborough County, and her estate instituted this wrongful death action. My client, Star Insurance Company, is the excess liability insurer for Hillsborough County. In the trial court proceeding, Dominguez filed a coverage declaratory judgment action directly against my client as the liability insurer for Hillsborough County. Hillsborough County did not join in the suit and did not file its own action against Star. It is undisputed that the respondent, Dominguez, has not entered into a settlement with or obtained a verdict against Star's insured Hillsborough County, and as such, we filed a motion to dismiss Dominguez's claim based on a very straightforward application of Florida's non-joinder statute and binding precedent from this court. The trial court denied our motion and this appeal followed. The non-joinder statute, which is codified at 627.4136 Florida statutes, very clearly provides that it shall be a condition precedent for a third-party claimant to sue a liability insurer that at first either obtain a settlement with or a verdict against the insured. The statutory mandate is clear and without exception. This is not a novel or complex issue, and the legal precedent on this issue is firmly established. I believe that probably the most informative decision on the issue is this court's Southern Owners versus Matthew opinion, which is a 2011 opinion. In that case, a homeowner in a construction defect case sued one of the liability insurers.
And that case also came up on a cert, correct?
That's correct, yes, Your Honor. And the panel in that case, which Judge Black was involved with, concluded very clearly that certiorari review is appropriate when insurer establishes non-compliance with the non-joinder statute, and that irreparable harm exists in that instance because the insurer is forced to litigate an action that would otherwise be barred if the requirements of the non-joinder statute are never met. And I don't normally like to do this, but I would, for the record, like to read the excerpt from the Matthew opinion because it is on all fours, and I believe it does completely dispose of the issue here today. The court held that the statute expressly states that a cause of action against an insurance company by a party who is not its insured does not accrue until a settlement or verdict has been obtained. To allow a party to avoid the application of the statute by merely instituting a separate action would result in insurers having to litigate claims which have not yet accrued and for which the insurer might ultimately bear no liability. Such an interpretation would nullify the protection offered by the statute. We therefore hold that where an injured third party brings a declaratory judgment action against an insurer prior to obtaining a settlement with or verdict against the insured, the action must be dismissed. The trial court's failure to do so in the instant case was therefore a departure from the essential requirements of the law. And, Your Honors, the Matthew decision, of course, is not the only decision on this issue. This court has, in fact, addressed the issue not once, not twice, but in 5 different opinions, and this court is not alone. Other cases throughout Florida, including the 1st District, the 3rd District, the 4th District, innumerable federal courts interpreting the non-joinder statute, I believe there are 14 decisions in all, have universally held that the non-joinder statute precludes such an action when the preconditions have not been met. I respectfully submit that the same result is warranted here. I think it's very notable that the respondent in his papers cites not one case that has allowed a third-party claimant to bypass the requirements of the non-joinder statute and pursue an action against an insurer when those statutory preconditions have not been met.
Ms. Curtis, did the judge below give any reason whether or not he distinguished the Mathieu case? You call it is it Mathieu or Mathieu, whichever way you pronounce it? I guess the French would be Mathieu. Did he give any reason as to whether he distinguished that case?
He did not, Judge, and it was an interesting hearing because Judge Pendino seemed to indicate on the record that he agreed with all of the cases that I cited. He agreed that they said what they said, but it seemed that perhaps he believed that by severing the coverage case from the wrongful death case, that cured any harm. And that, of course, is not the case. That is one of the issues that respondents have made in their brief, the irreparable harm issue. Despite the fact that this court and others have held that there is absolutely irreparable harm when an insurer is forced to defend a case that would otherwise be barred, that because the coverage case has been severed, somehow that cures the harm.
Well, even in Mathieu, that was just a separate freestanding deck action. There wasn't anything else involved with it, correct?
That's exactly right, Your Honor, and that was exactly what this court said in that decision, is the fact that it's a separate freestanding case still doesn't cure the noncompliance with the statute. The severance cases that respondent relies on that discuss severing a coverage case from a liability case are cases where the insured filed the deck action against its insurer. And of course, those deck actions go on every day, but they have to be severed from the liability case. So in each one of those cases, it was the insured properly suing its insurer for declaratory relief. Of course, Hillsborough County has not done that in this case, but those cases do not cure the third-party claimant's noncompliance with the statute, which is what we have here. We have a third-party claimant impermissibly suing the liability insurer when they have not complied with the non-joinder statute, totally separate and apart from a declaratory judgment action filed between insured and insurer.
Let me ask you this question. Your opponents direct us to 4 Florida Supreme Court cases that have been decided since 2012 that have to do with defining cert jurisdiction and making sure that we don't overextend in that respect. And I suspect they'll argue that despite Southern owners being mature, or whatever it is, and the others, Judge Kazam speaks French, so I'm very self-conscious about how I pronounce it, that maybe this is the right time for us to say, you know what, we need to back off of some of these cases. What do you think about these Supreme Court cases and that argument?
I think that several of the decisions are distinguishable, and I think that the main case, the citizen case, can actually be harmonized with the Mathieu decision and the other decisions from this court. One of the cases, the Keck case, doesn't even address cert review because there was an amendment to the rule to deal with an immunity defense. Another one of the cases was an overbroad discovery order, which is entirely distinguishable. So the 2 cases that I really focused on were Rodriguez and Citizens, and both of them discuss qualified immunity as a defense to liability, that an employee of a sovereign entity is immune from liability. And in the Rodriguez case, it was the denial of a summary judgment motion, and there were factual issues in dispute as to whether that employee acted in bad faith or with a malicious purpose. And the court held that in that situation, the prejudice, so to speak, in having to continue to litigate that case through finality would not justify the extraordinary remedy of cert review. And then the Citizens case, which was very similar, made a distinction between what was at issue in the Rodriguez case, which is a defense to liability. And if you have a defense to liability, it's an immunity defense, it's a defense to liability, you don't lose that immunity by having to go through the entire case. But a defense to immunity from suit, which is what the non-joinder statute is, it's immunity from a suit by a third-party claimant, results in irreparable harm when the party that is immune from suit is subjected to the litigation from which it is protected. And so I think when you read the Citizens case and the distinction that is made, that can be harmonized and is consistent with the opinions that find irreparable harm in this case, because the NonJoinder is akin to a statute that provides an insurer with immunity from suit unless those preconditions are made. There are no factual disputes. It's undisputed that the preconditions have not been met. So I believe that the cases are consistent and can be harmonized and would not require this court to reconsider its prior opinions. The next argument that the respondents make is that my client somehow has waived the protection of the NonJoinder statute, and the argument is this: because my client, the insurance company, will not consent to a settlement between Hillsborough County and the claimant, that somehow we are preventing the performance of the statutory, of the settlement precondition under the statute, which equates to some kind of waiver. This argument, again, it's completely unprecedented, and it's not supported by a plain reading of the statute. The cases that respondent relies upon in support of this waiver argument are two different lines of cases. The first are cases where a party waives a statutory precondition by failing to raise it in its answer or its defenses, or failing to timely raise it. That's not what happened here. My client immediately asserted the protection of the NonJoinder statute in its motion to dismiss, which was its first pleading. There's been no waiver. The second line of cases are contract cases dealing with prevention of performance, where one party's conduct literally prevents the occurrence of a contractual precondition. And the cases all involve real estate broker commissions, where a broker is denied his or her commission because the client won't go through with the sale transaction. They have absolutely no relevance to the issue before the court. The NonJoinder statute is very clear, and it contains no exceptions. If the legislature wanted to create an exception to say, okay, well, in an instance where an insurer is objecting to a settlement, then, okay, nobody has to comply with the NonJoinder statute. There is no such exception. If the legislator wanted to create it, it could have, but it didn't. And I respectfully submit that this case is no different than any other case where an insurance company will not consent to a settlement between its insured and the claimant. It happens every day. And in that case, the insurance company cannot literally prevent the parties from entering into a settlement. They can enter into the settlement over the insurance company's objection, and that happens every day. It happens all the time. And then what happens is the claimant now has its settlement. They seek to enforce that settlement against the insurance company. The NonJoinder statute is no longer a bar, and then the insurance company is just left with arguing, well, there's no coverage, or the coverage is voided because that was an unauthorized settlement. But that is something that happens every day, and frankly, it's a risk that a claimant and an insured bear when they opt to enter into a settlement over an insurance company's objection. But it is absolutely not an end run around the mandatory requirements of the NonJoinder statute, and there's no authority that would support such a result. So in sum, we respectfully submit that allowing the respondent to proceed with this action against Starr without complying with the NonJoinder statute would be unprecedented. It would be contrary to established decisional law, and it would clearly subject my client to irreparable harm. And we therefore respectfully request the court to grant the writ of certiorari and quash the trial court order. Thank you.
All right, thank you, Ms. Curtis. You've got 5 minutes left for rebuttal.
Thank you, Your Honor. Good morning. Richard Harrison for the respondent, Jorge Dominguez. I'd like to take just a minute or two to explain how we got here and why we're here. The facts, I think, are somewhat extraordinary and not quite as straightforward as counsel suggests. They also then lead us right into the discussion of why we believe the insurance company in this case has waived the statutory condition precedent of a settlement. And then I'll talk a little bit about the broader jurisdictional question that we've raised in our response. Mr. Dominguez, our client, lost his wife. His 3 daughters lost their mother through the negligence of a county employee operating a county-owned semi-truck in the course of his county employment. Nobody seriously disputes these facts. The vehicle broke down on the interstate highway. Instead of removing it from the road, the driver left it in the lane of traffic. It was early morning, and you can imagine what happened next. The car driven by Mrs. Dominguez plowed into the back of this vehicle. We don't need to go into these details. The county does not seriously dispute liability in this case. In fact, the county would like to settle with us to their credit. Mr. Dominguez is prepared to settle his claims on behalf of the estate and his 3 daughters within the limits of the auto policy issued by Star. The county, to their credit, is prepared to settle within the limits of that auto policy. The sovereign immunity statute says, 768.285, which you don't hear counsel talking about, by the way, says a sovereign insured, notwithstanding the sovereign immunity cap, and we're under the old statute, so it's $100,000. The statute says plainly, the sovereign may settle a claim up to the limits of any applicable insurance without further action of the legislature. Great. Mr. Dominguez wants to settle, the county wants to settle, the statute says the county can settle up to the limits of the policy, and yet here we are. Why is there no settlement? Because the insurance company has told the county, you, county, cannot do what the statute says you can do. You cannot settle this case without our consent. Number one, the statute doesn't require their consent. You cannot settle up to the limits of the policy, even though the statute says plainly, unequivocally, that you can. And we, the insurance company, are not going to pay any penny more than the $100,000 sovereign immunity cap unless and until you go to trial, get a verdict, and a claims bill is passed for any excess over the $100,000. So the insurance company has told the insured, the county, you can't do what the sovereign immunity statute plainly says you can do. In fact, you have to do exactly what it says you don't have to do. And oh, by the way, if you try to settle this case without our consent, you might just void your coverage entirely. That's why there's no settlement. And that's why we're here. Next.
Let me ask you this question, Mr. Harrison. Opposing counsels told us that the county had not filed its own deck action against the insurance company. Is that correct?
That's correct. The county did not bring this action. It was brought by Mr. Dominguez.
So they haven't filed a separate action either?
Correct. They have not filed a separate action. And Mr. Todd can speak to that on behalf of the county.
Because wouldn't that, by filing a deck, they had every right, they could have filed a deck action. Wouldn't that have rendered this whole non-joinder statute?
Yes.
Moot?
Absolutely, yes. If the county had filed the exact same declaratory judgment action that Mr. Dominguez filed, we wouldn't be here because there would be no issue about the non-joinder statute. You're absolutely correct. I don't want to speak for the county as to why they chose not to file that case. Mr. Todd can address that. But you're absolutely correct. If they had filed it, the non-joinder statute has no application whatsoever. So what has this done in terms of the county's ability to settle with us? And this is alleged in the complaint, specifically in Exhibit D to the complaint, which is the letter from the county attorney that sets all this out. Basically, here's why we cannot enter into a settlement with you. Lays all this out. Despite the sovereign immunity statute that plainly says the government can settle up to the limits of insurance, the county has been now put in the position of either having to settle and run the risk that it voids the coverage, or having to go to trial and run the risk of an excess judgment.
What's so unusual about this situation? I mean, don't insurance policies, liability insurance policies, generally give the insurance company the right to approve settlements? Well, that's not odd, is it? It's not odd, but again, we have to look beyond the policy to the statute because, of course, under Florida law... You haven't answered my question, though. Don't insurance policies generally give insurance companies that kind of a right?
Yes.
So what's so unusual or strange about this?
Because the statute is as much a part of the policy as what the policy says. Under Florida law, the statute is as much a part of the insurance contract as though the words of the statute are written in the insurance policy. And the statute says when we're dealing with a sovereign, the statute says the sovereign can settle up to the limits of insurance without any further action of the legislature. You don't have to go to trial and get a verdict and have a claims bill passed.
An individual can settle too, but might void their coverage if the insurance company doesn't agree.
Well, that's right, but the individual doesn't have the benefit of the statute. The statute doesn't require...
The statute can't compel coverage. It's a contract question.
Well, that's right. It can't compel coverage, and counsel kept referring to this as a coverage claim.
The claimant could still enter the settlement. They just might have a coverage problem.
Well,
like every other case.
but nobody's denied coverage in this case. There's been no denial of coverage. This is not a deck action that says, even though counsel kept calling it a coverage case, we didn't file a deck action that said, Judge, please declare that there's coverage under the policy. What we said was, Judge, please declare that the county has the right to settle with us up to the limits under the statute because the insurance company is taking the position that they don't have that
Not
right.
just settle, but also bind the insurance company to provide coverage. That's what you're asking for, correct?
That's not what we asked for in our declaratory judgment case. What we have said is we have asked the court to declare that the county has the right to enter into this settlement without voiding the policy.
All right, well then
Because-
that's binding the insurance company.
Yes, in a sense it is.
Cases in the NonJoinder statute says you can't do that.
Well, there's a long line of cases that counsel has covered thoroughly that say you can't typically do this. This is a different scenario because we're suggesting that through its conduct, the insurance company has waived the statutory condition preceding. The county wants to settle. The plaintiff, Mr. Dominguez, wants to settle.
What's your best case supporting your argument on that position?
Well, there's certainly no case that talks about a waiver in the context of the NonJoinder statute. None of the cases that counsel has cited, and we didn't find any either, specifically address waiver. So we have to look beyond the NonJoinder statute. We have a statutory condition preceding. The insurance company agrees with us that statutory conditions preceding can be waived. They said that in a footnote. They would like to think that the only way they can be waived is if you fail to raise it in your pleading. And we suggest that no, just like the contractual doctrine of prevention of performance, just like the equitable doctrine of prevention of performance, they can be waived through the conduct. The insurance company cannot act in a manner that is completely contrary to the statute.
If we were to agree with you and write an opinion that says what I seem to hear you saying, it seems like we would be invalidating every clause in every insurance policy that gave the insurance company the right to approve a settlement.
Well, no, I don't think that's true at all because, again, we're not talking about every insurance policy. We're only talking about insurance policies that are issued to sovereign entities covered under the sovereign immunity statute.
Well, I don't know how you could contain it and limit it in that way.
Well, because a private insured, Sears, does not have a statute that says they have the right to settle up to the limits of an insurance policy. The county has that statutory right because the legislature gave it to us precisely so the government doesn't have to go to trial, run the risk of an adverse judgment, and then worry about somebody trying to get a claims bill passed.
I guess, Mr. Rizzo, this could have easily, I know you're saying they don't want to go to trial, they don't want to get this, but it could have been easily remedied by them filing a deck action.
I completely
Period.
agree with you, Judge.
And all this outrage about they're not offering to settle, all that will be rendered moot and will be done and will be over.
I completely agree with you, and I wish I had a better answer other than I completely agree with you, but the county is here, and I hope you'll ask that question of the county. So the issue is not that we disagree with what the existing body of non-joinder cases say. They all say what they say, and we understand that. We recognize that. We're not trying to mislead anybody. What we're saying is, through the conduct in this specific set of facts, the insurance company has prevented the settlement from occurring that everybody agrees would then allow us to proceed. So you have a condition preceding. Their conduct has prevented it from occurring, and now they're here defending, saying you can't sue us because you didn't meet the condition preceding. That's the waiver argument.
So in order to do what you're asking, we would have to carve out some sort of exception to the DCA law for a sovereign.
No.
To our southern owners, the Matthew and the other cases.
No, because none of those cases deal with the question of a waiver, number one. In none of those cases was the plaintiff in the declaratory judgment action alleging that the conduct of the insurance company waived the condition preceding.
What conduct are you referring to?
The conduct of the insurance company in telling its insured, contrary to what the statute plainly says, that you don't have the right to settle up to the limits of our policy.
How's that a waiver? It sounds to me like they're just asserting their contractual right.
Well, they can't have a contractual right that conflicts with the statute. The statute supersedes anything in the contract. They can't have a contractual right that imposes a requirement that the statute doesn't impose. That statute is as much a part of the contract as anything that they write into the contract. And so what they've done is to the insured say, you cannot do what the legislature has given you the unequivocal right to do, and if you try to do it, you're at risk of either voiding the policy if you do it without our consent, or if you do what we're telling you you have to do, you're then at risk of having to go to trial and face a possible excess judgment. None of that is what the legislature intended. There's nothing in the statute, in the sovereign immunity statute.
Are you saying that by writing the coverage, STAR is forfeiting the opportunity to take the position that to refuse to settle within the STAR
Yes.
policy limits?
Yes.
You're saying that once they write the coverage, they give up any say in it?
Yes.
No
Once
matter
they
explain what the contract says.
The contract cannot say anything that conflicts. Yes.
That's the waiver.
Yes.
The waiver is they wrote the coverage.
They wrote the coverage to a sovereign entity, and the sovereign entity is covered under the statute, and that statute is as much a part of the insurance contract as the words they wrote on the policy. That's the basis on which they wrote the policy. It's not a surprise to anybody. They wrote the policy to a sovereign entity. They took a premium from the sovereign entity, and the sovereign entity has the absolute unequivocal right to settle up to the limits.
Should they waive all coverage defenses by
No.
writing the coverage?
No. But they haven't
Which one should
asserted.
they waive?
But they haven't asserted any. There is no coverage defense. Nobody's denied coverage. There's been no denial of coverage. There's just been a letter written, a position taken that says you can't do what the statute allows you to do. That's the waiver. And again, we're here following a motion to dismiss. So the court does not have to determine that a waiver has occurred. Nobody's determined whether a waiver has occurred. The court denied the motion to dismiss, severed the declaratory judgment action. So all that anyone has to be concerned about today is, have we alleged enough in the complaint, if you take those facts as true as we must, to show that a waiver has occurred. Not whether we can prove any of it. Nobody's made any decision on the merits. That leads into the perhaps broader question that Judge Black has suggested about these recent Supreme Court cases, and is the court telling us that we need to look a little more closely at this concept of irreparable harm? I think the answer is yes. I think those cases plainly say we need to confine ourselves. We need in every case coming to us on a cert petition to make sure we have examined closely whether there's a type of harm that's really irreparable harm.
So if we agree with you, will we need to go in bank and recede from Southern owners and other cases?
No, I don't think that you would.
How so?
Because in every case, well, the court has to decide whether there's irreparable harm or not. We have a line of cases. We have really two lines of
But
cases.
we've already said that repeatedly.
Right.
And now you're suggesting that the new cases suggest that there's not irreparable harm. So wouldn't that require a full court, full en banc proceeding to say, look, we're going to back off of Southern owners and these others because of the Supreme Court cases? How?
I don't know the answer, Judge. I think if this panel wanted to recede from a prior opinion or a line of cases, I think you would have to go en banc to do that, if you were going to spontaneously do that on your own. If you're receding because the Supreme Court, in some intervening case, has said we need to look at this differently, I don't know the answer. I don't know whether that would require a further en banc consideration. I think certainly if you decided you were going to do it on your own, you're right. What those cases suggest, and the reason we brought them up, is simply that the Supreme Court is telling us we've got to look at this question of irreparable harm. And again, we know what the cases, the existing cases, say. What we're suggesting to the court is that there is a disconnect.
Right, Mr. Harrison, you're at 15 minutes, so
Okay.
if the county wants its time, it's
Thank you.
they have 5 minutes.
Thank you, Your Honor. Stephen Todd for Hillsborough County. Judge Kuzan, to address your question. The county cannot file a DEC action because we are very concerned of the position that the insurance company will take, that our having filed a DEC action is a lawsuit, which under the terms of the policy can void the policy. So that's the reason the county has elected not to file the DEC action in this case. And while Dominguez has a simple way to rectify this problem, is if Ms. Curtis disagrees with our position on that, she can certainly state it on the record. This case can be mooted, kicked back, the county will file a deck action. Very simple.
Because, Mr. Todd, there are, I would say, numerous number of deck actions filed on a daily basis in the circuit court. I've had quite a lot when I was presiding in Pinellas County. It's not new, it's not novel, and by filing a deck action, it's not I guess when I read this, this could have easily been resolved by filing a deck action. A deck action means you're unsure, you're not bringing suit against them, you're just asking the court for guidance. What are our rights? We're unsure of our rights. So, respectfully.
I appreciate that assurance, Your Honor, and that's the assurance that my client needs.
Am I giving you legal advice on me?
I appreciate that, Your Honor. My client doesn't want to risk having to pay, $2-3 million out of the taxpayers' money because of defense that could be raised based on the terms of the policy that the county's filed a lawsuit. It might be a deck action, but it's a lawsuit, and because we filed a lawsuit, we're out of town. We're not going to cover your loss. And that's the reason for the insecurity of the county in this particular situation. Again, it can be easily rectified by Ms. Curtis, elaborating on their position regarding whether her client intends to take the position, if the county were to file a deck action, that such an act would void their policy terms. As to the balance of our argument, the waiver argument that Mr. Harrison was bringing was based upon 768.28 Florida statutes, and the specific language I'd like to read is as follows: notwithstanding the limited waiver of sovereign immunity provided herein, the state or an agency or subdivision thereof may agree within the limits of insurance coverage provided to settle a claim made or a judgment rendered against it without further action by the legislature. In other words, without a claims bill. The insurance company's taking the position that they're offering claims bill insurance, that the only way that they're going to pay is that there's a claims bill that authorizes this. This court well knows claims bills are rare. It's a pretty low risk for the insurance company to have such a policy. This provision of Florida law says nothing about requiring the consent of the insurance company before the county can agree within the limits of the insurance coverage to settle a case for an amount within the insurance coverage. There is no qualifier, there's no term in that statute that says you can only settle if your insurance company agrees. We're a local government, we're not a private entity. That distinguishes the county in this situation from other entities that have to deal with the NonJoinder statute as we are here today. Here, Hillsborough County simply wants the opportunity to exercise its unilateral statutory right to enter into a settlement of litigation within its policy limits. That's all we want in this case. We want to be able to sit down at the table, resolve litigation. The only thing that's preventing us from doing that is Starr's position in this case. If we can't settle the case.
I don't understand. I mean, this is a right that insurance companies, liability insurance companies, have under their policies, is to agree or not to agree to a settlement. So, I mean, you're arguing that you can, by virtue of the statute, you can now force them to a settlement that's binding on the company without their consent? Is that the argument?
That's the argument based on the clear language of the statute, Your Honor. The language of the statute trumps the policy. There's no qualifying language in the statute that says you got to get the approval of the insurance company before you can settle.
So you think the legislature, when they wrote this statute, intended to override policy provisions that give the company a veto power over settlements?
All I can say is that the clear language of the statute indicates that that was their intention, Your Honor. There's no qualifier whatsoever. In addition, they use the term notwithstanding as the qualifier.
Is there a case that you rely on or
no, sir.
To
There's
support that?
No case law that I'm aware of in support of this position, as I believe the provision is relatively new. But because the statute is express and clear on the subject and requires that the county can go ahead, based on the authority of my client, I can sit down with the plaintiff's attorney, settle the case for $2 million today, obligate the insurance company to pay the amount of their coverage minus the amount of the statutory cap under
How about
768.28.
legislative history? Have you looked at the legislative history? Is there anything there that we could look at that would support your interpretation of the statutory language?
I have not reviewed it, and it's not part of the record in this case for this court to review. I'm just relying on the express language of the statute solely and exclusively, without the benefit of case law or legislative history.
Okay, I've let you go over, so you need to wrap up at this point.
Yes, sir. I'll wrap up simply by saying that STARS created a catch-22 situation, which really hamstrings the county and puts it in a position where it can't do anything. I'd like to hear the response from Ms. Curtis with regard to the position, the concern that Judge Kazam has. Thank you, Your Honors.
All right, thank you. All right, Ms. Curtis, you have 5 minutes for rebuttal, ma'am.
Just very briefly, we hear over and over again what the county wants to do, and the county has been put in this position. The non-joinder statute, as Judge Kazam indicated, doesn't prohibit the county from filing a declaratory judgment action. It's not barred by the non-joinder statute. What is barred is the claimant's claim against STAR. It's very clear. And the argument that the sovereign immunity statute should be read in conjunction with the non-joinder statute to create some sort of an exception is an argument that was rejected by the First District in the Cincinnati insurance opinion, not on this precise issue, but it's cited at page 7 of our brief. And in that case, the insurance company failed to comply with the insurance disclosure statute, and the claimant filed an action against the insurance company, did not comply with the non-joinder statute. There was no settlement, no verdict. And the trial court, in denying the insurance company's motion to dismiss, read the insurance disclosure statute in conjunction with the non-joinder statute and said, okay, I'm going to find that because the insurance company didn't comply with the disclosure statute, it can't assert the protections of the non-joinder statute. And the First District Court of Appeal quashed the trial court's order and expressly rejected an interpretation of the non-joinder statute that looks to other statutes. And again, I would like to read what the First District said. The First District said, where the language of a statute is so plain and unambiguous as to fix the legislative intent and leave no room for construction, admitting but one meaning, courts may not depart from the plain language employed by the legislature. The court went on to say, while a trial court has authority to compel a recalcitrant party to obey a statute and to impose appropriate sanction for the party's failure to comply, it does not have the power to ignore or amend another statute in its creation of an implied remedy.
Because, Mr.
Your
Curtis, when I mentioned to Mr. Todd, deck actions are they've been employed, if I would say hundreds of cases, situations, perhaps, I mean, some are very similar to here. These go daily on the circuit court. Am I mistaken?
You're absolutely correct, Judge, and I would be willing. The request has never been made by the county on STAR for clarification. If we file the deck action, does that void our coverage? I can represent on the record that Hillsborough County merely filing a deck action, that STAR would not assert voidance under the policy. STAR would assert all defenses that it has, if possibly advisory opinion, case or controversy, and would of course rely on all of the defenses that it has under its policy. But I can say on the record that the mere filing of a deck action by Hillsborough County, STAR would not take the position that just the mere filing of a suit somehow voided its coverage.
I'd be surprised if STAR would have taken that position.
Okay. Thank you. I have no further argument.
All right, thank you both. We're going to take a 10-minute recess at this point. We'll come back and do the last case.